Afternoon, everyone. Thanks for joining this session. Firstly, thanks for everyone dropping in today. We know it's a really busy time of year, and particularly this week with the hotly anticipated budget announcement. We'd like to think we'll be a little bit more favourably received than that, but those of you that have been to our previous webinar or the roundtable sessions will know that this is a Renters' Rights Act webinar, which is a big overhaul of the landlord and tenant law, definite shift towards more tenant-friendly rules, and the role of the agent is going to become much more important in keeping and ensuring compliance. Just an initial bit of housekeeping, this webinar is being recorded. It will be circulated later if people would like to see it. I'm Josh O'Neill. I'm an associate in the property litigation team at Ashford's in the Exeter office. I act on a wide range of property-related matters with an emphasis on landlord and tenant. The session is being co-hosted by Emma Hinden, who's also an associate in our Exeter property litigation team. Emma specialises in a wide range of contentious landlord and tenant matters for local authorities, registered providers, and private landlords. Next slide, please. Thank you. Just in terms of an agenda, what we've got is a kind of introduction to the new law that's coming in, discussion around the key changes, what and when, how to expect them, how to prepare for them. And then what we've done is set up 3 case studies with kind of common themes that people would previously have seen and how the new law might apply to them. There is a live Q&A, and we'd encourage people to put as many questions as you can in those. We will answer your questions at the end. We might not have an opportunity to answer all of the questions, but what we'll do is we'll point you in the direction of our other materials online, and we'll be very happy to speak to anybody offline as well if there's any particular questions people have. One point I would just make in relation to our case study, I'm obliged to say this, the case study is purely fictitious, and any possible resemblance to a real person, dead or alive, is purely coincidental. Okay, in terms of introduction, the Renters' Rights Act received Royal Assent on the 27th of October 2025. The Royal Assent is the final stage of turning a bill into an Act of Parliament. There's quite a lot of potentially misleading jargon out there suggesting that the Renters' Rights Act is currently in force. That's not quite correct. The Renters' Rights Act is coming out in 3 phases, starting on the 1st of May 2026. What this means is the current law as it currently stands is in place until the 30th of April 2026. So I'm going to cover off the key changes under the first phase, and like I said, that kicks into effect on the 1st of May 2026. We're not going to go into these in too much detail for the purpose of this session, but it's just going to highlight some of the key points that we think people will need to know now, and then they'll be applied in our case studies. So new assured periodic tenancies, as of 1st of May, all assured tenancies will be periodic. The period will be dictated by the period at which rent is paid. All fixed terms will be abolished, including any fixed term tenancy that might apply now with a fixed term that should extend beyond 1st May. There's an abolition of rent in advance above 1 month's rent. There's the headline abolition of Section 21, which is the no-fault eviction process. There is a transition in relation to current Section 21s, and as I said, the current law is in place until 30th April 2026. We can cover off transitional periods and current Section 21s if there's any questions on those. To account for the no-fault eviction process being closed off, there is an expansion of certain grounds under Section 8 and the introduction of other grounds. Probably the key one to really pull out, which is going to be of most significance to our case studies and also to landlords out there, is the introduction of ground 1A, which relates to the sale of a property. This requires a 4-month notice period and for the tenancy to have started at least 12 months prior to the expiry date on the notice. A really key provision on this as well is that a property cannot be relet for a period of 12 months, and that 12-month period relates to both the start of the the start of the notice period, the expiry of the notice period, and potentially the court proceedings as well. It's a fairly complicated structure to work out, but essentially, if you work on the basis that you have to serve a 4-month notice period, and then 12 months after that, you'd be looking at 16 months from serving that notice where you can't re-let a property or you'll face penalties. There are other grounds introduced relating to student properties because student market is going to be hugely affected by this, and particularly the removal of traditional fixed terms. There's an expansion of what would be considered family under the current rules relating to recovering a property for the landlord or their family. And there's a headline amendment relating to serious rent arrears where they've shifted the amount of arrears needed up from 2 months to 3 months and the notice period from 2 weeks to 3 weeks, 2 weeks to 4 weeks. And so that's expected to kind of bite in, particularly for those landlords who are going to have properties with tenants not paying, might potentially see those periods extended longer than currently. Other headlines: new procedure for increasing rent. There'll be no capacity under the Renters' Rights Act for a contractual rent review. It will all have to follow the statutory process. There'll be a ban on encouraging, inviting and accepting rental bidding. Landlords and agents will be required to advertise rent at a fixed price, and there'll be penalties involved in accepting or inviting rental bidding. There's a right to request a pet, and there's an obligation on the landlord not to unreasonably withhold consent and refuse a request. Another big headline, really, which is going to affect the market significantly, is that tenants can give 2 months' notice at any time to end the tenancy. And because there's no fixed term, that could effectively be on day one of a tenancy. And there's another final point to make, which is just about rental discrimination and to take away practices which would be direct or indirect bans on those tenants with children or in receipt of benefit. Phase 2, this is really 2 headlines that come out of phase 2, and it's expected to come in from late 2026. First is the private rented sector database. This will be a paid membership database and provide information about properties. Secondary legislation is going to put a bit more detail into what this is actually going to mean, but what we think it's going to include is details of the landlord, details of the property, details of safety compliance, and initially it's going to be rolled out for local authorities and landlords. And like I said, that's expected late 2026, and the second stage will be for that to be rolled out nationally with public access. Second part of phase 2 is the landlord ombudsman. It's a mandatory system for all private rented sector landlords. This will aim to be a one-stop shop for tenants who want redress, so they will no longer have to go through the court process. The first stage of that is going to be appoint an administrator. 12 to 18 months from that, you can expect implementation. At the moment, that's looking at potential implementation and registration by 2028. Again, as far as we're aware, there's no current administrator or person in place to design and build this system. So whether that's optimistic or not, I think time will tell. But that's the key part of phase 2. Emma's going to take over and just talk about the phase 3 and how landlords can help implement and prepare.
Thanks, Josh. So, hi everyone. I've got the fun job of describing the future policies that are going to be coming in under the Renters' Rights Act. So the first one I'm going to talk about is the new Decent Home Standard. So the Renters' Rights Act is going to introduce the new Decent Home Standard to the private rented sector for the first time. So this will ensure that all private rented sector properties meet the minimum standard of housing quality. And it's also going to provide local councils with the power to take enforcement action if the private rented sector property doesn't meet that standard. So the government consulted on the Decent Home Standard between July and September this year, and they've proposed that it's going to come into force in either 2035 or 2037. I'm not entirely sure what the government know about 2036 that we don't know, and why they haven't proposed 35, 36. But they are currently considering the consultation responses, and they will announce the details of the standards and confirm the implementation timetable in due course. I imagine they've gone for a period of 10 years, because it's going to require a lot of work to get these properties up to the decent home standard. And clearly they're not going to want a situation where as soon as the decent home standard comes in, there's hundreds of thousands of properties that are already in breach. So something that's coming in sooner than 2035 is AWAB's law. So I'm sure many of you have already heard of AWAB's law, which has already been implemented to the social housing sector earlier last month. So the law was introduced following the tragic death of a 2-year-old, AWAB Ishak, in December 2020. He died as a result from prolonged exposure to mold in his family flat. And it was revealed that there had been multiple complaints to their housing provider regarding the mold. So the failure to act on these complaints highlighted the significant shortcomings in housing standards, and this is what prompted the widespread call for stricter regulations to protect tenants. So this is, like I said, this is currently already in place in the social housing sector, but paragraph 60 of the Renters' Rights Act extends AWAB's law to the private rented sector. So this will mean that landlords will need to make sure their homes are safe and that they respond to serious hazards within strict timescales. So the government have announced that they're going to consult on the policy, including the implementation date. So we don't actually know for sure what the date's going to be, but the current commentary on it suggests that this is going to be implemented sometime around 2026, 2027. So watch this space for that one, because it's likely to happen a lot sooner than 2035. And then finally, the minimum energy efficiency. So the government has consulted on plans to require all domestic private rented properties in England and Wales to meet a minimum energy efficiency of a C or equivalent by 2030, unless, of course, there's a valid exemption in place. So again, we're still awaiting the government's response to the consultation on this, but it's anticipated and it's been previously confirmed that that's going to probably be around 2030. So moving on now you know the 3 phases and what to expect under each phase, how we should prepare for that. So obviously preparation is key, and good preparation is going to require guidance and advice. So the government guidance for landlords and their agents is expected to come out some point this month, but obviously we are on the 26th of the month. So I think it was hoped that it was going to come out at the point that they had Royal Assent, but clearly they hadn't quite got their ducks in a row yet. So hopefully that when that does come out, it's going to clarify the implications of the Act and what landlords and agents need to do to comply straight away. Also, obviously, professional advice is going to be a critical part of the preparations. So landlords thinking about recovering possession of any of their properties need to take prompt action to take advantage of the no-fault Section 21 process before it's abolished in May. The government's also going to be key in preparing for implementation. So we are waiting for certain government templates to follow. They've said that they will be issuing a new tenancy agreement template for those agreements which are entered into on or after the 1st of May, which will of course be the assured periodic tenancies. And also they will be issuing an information sheet, which they have advised will be online from March 2026, so implementation of phase 1. So, and that's going to be for all tenancy agreements. So that's going to explain the tenant's rights and protections under the new law and give information about how to end a tenancy, rules on rental increases, possession grounds, where they can go to get help. And this information sheet is going to have to be provided to every tenant, regardless of whether they have a written tenancy or not. And current timescales suggest that this information sheet is going to have to be provided by the 31st of May. So you're going to have sort of a month from implementation to get it sent out on all properties. Obviously, at the moment, we don't know what this information sheet is going to look like, how extensive it's going to be, what details are going to need to be put into it. But I'm sure as soon as we've got some kind of document that's been released by the government, we'll be able to issue some more help and assistance on that. And then finally, as always, I'm sure you're probably fed up of hearing us say this, but landlords and agents are going to have to look at reviewing and drafting new policies to put in place to regulate the processes relating to things like property allocation, how they take on board tenants, what to do during the term of a tenancy, what to do at the end of a tenancy. Obviously now tenancies aren't going to have fixed terms, so the end of a tenancy is going to be unclear, but there's going to need to be documents and procedures in place that replicate the new obligations. The Renters' Right Act is imposing a new duty on landlords to provide what they're calling a written statement of terms. before an assured periodic tenancy is entered into. So that's the new tenancy. Again, we're waiting on more guidance from the government on what's required to be put into this statement of terms, and hopefully that's going to be in place before the 1st of May 2026, so the first phase. But what we are anticipating is that's going to be a document which sets out the core contractual terms, things like rent amount, payment dates, details of the landlord and tenant, property address. And more than likely, this is going to need to be served on all new tenancies from the 1st of May, and any existing tenancies that are oral in nature will need to be given this written statement of terms by the end of May. Again, we assume that's just to ensure that all tenants have clarity on the new terms, the new Renters' Rights Act, and what they need to do to stay compliant. So, before we go on to our case studies, which Josh talked about earlier, we thought it would be beneficial to discuss some of the definitions, or rather the lack of definitions in the Act, because those are going to be some of the things we talk about in the case studies. So the first one is relevant person. This is mentioned 78 times in the Act, and it's got a different definition depending on what section and what chapter it's mentioned in. So that's particularly infuriating. In chapter 6, which is the prohibition of rental bidding and accepting more than 1 month's rent in advance, a relevant person is defined as a person involved in a proposed letting, meaning the landlord, prospective landlord, or a person acting or purporting to act on behalf of the landlord or prospective landlord. So it's quite a wide definition. Civil penalty is defined as a financial penalty which is imposed by a local authority on an individual or an organisation. So again, this opens up the penalties in the Renters' Rights Act to both the individual and also the organisation that individual works for. And then entered into, this is the one that's been causing us the biggest headache so far. Mainly because it just doesn't reflect practice. So it's mentioned 61 times in the Act, but it's unclear as to what entered into means. So obviously in the Act, it's used to describe the process of entering into a tenancy, but the reality is that doesn't reflect practice. So as many of you will know, in practice, you have a period where you're kind of signing the tenancy, but it hasn't actually come into force yet. And then you'd have a time when you date the tenancy agreement or complete the tenancy agreement, at which point it becomes enforceable and legally binding. Entered into doesn't meet either of those dates, and there isn't a definition as to which one we are expected to use for entered into. So based on our understanding of the process of entering into a tenancy, we consider that the earliest date that a tenancy could be considered to be quote unquote entered into would be the date both parties sign a tenancy agreement, because clearly they haven't entered into anything before that date. And then the latest date that could possibly be would be the date both parties, the date that it comes into force, so i.e. completed, so dated and actually enforceable. I imagine there's going to have to be further guidance on this at some point because of the fact it's mentioned so many times in the Act, and there is obligations that follow from the definition or lack of definition of entered into. So what we would suggest at the moment, until we get that guidance, is that landlords and agents look to include their own definition within the tenancy agreements that they're drafting, using basically creating a new definition of entered into, and based on practice and how tenancies operate, it seems to us that the most sensible definition would be the date that the tenancy is dated and actually enforceable. So, moving on to the case studies, which is by far the most interesting part of this webinar, I'm just going to take you through case study 1. So you're going to need to put your future hat on to consider these, because obviously all of these scenarios are based on the Renters' Rights Act being in force, so that we can consider any potential breaches and what those breaches might look like. So the first scenario is from June 2028. And I'll just quickly read it through for you, although it is summarised on the next slide, so don't worry too much if you're not following. So Hindon Homes, a mid-sized letting agency in Bristol, advertises a ground floor 2-bedroom flat for £1,000 a calendar month. Victoria, a single parent with 2 children, applies for the property. She provides strong references and meets affordability checks. Shortly after Victoria submits her application, Warren offers £1,200 per calendar month to secure the same property. The landlord instructs the agent to go back to Victoria and ask her to match Warren's offer and pay 6 months' rent in advance. The agent informs Victoria to secure the property, she must increase her offer to £1,200 per calendar month and also pay 6 months' rent up front once the parties have entered into the agreement. When Victoria explains that that's unaffordable for her, the agent says that the landlord prefers tenants without children anyway because children cause more wear and tear. I mean, I have a child and that is probably actually true. But anyway, moving on. So, discussion questions following this case summary. So, Josh, having just heard case summary 1, which provisions of the Renters' Rights Act have been breached and by whom? What policies should agencies implement to prevent discrimination against families and applicants in receipt of benefits? And is it a balancing act between commercial reality and the law? How can agencies balance landlord preferences and demands with legal compliance? What's your thoughts on this one?
Perfect. Thanks, Emma. I think the first thing to note really is that this is quite an atypical situation. And if you're a landlord wanting to maximise the rental yield, or you're an agent, looking to do your best by your landlord, you might see this scenario and think, well, you've got someone here who's clearly wanting to pay more rent up front. This must be a good thing. The law shouldn't penalise me from doing that. And unfortunately, you'll see that that's just not the case. The first thing that really sort of jumps out is Hinden Homes has done the right thing in advertising the rent. So that's a tick. However, following that, they've engaged in a practice of inviting, encouraging, or accepting a sum above that advertised rent, which is a problem under the Renters' Rights Act. I mean, that's certainly one breach in relation to Warren. Emma, do you think there might be anything else in relation to that aspect as well?
I think you're definitely right there in terms of the first breach, but I also think there's probably a second breach in there as too, by accepting the higher offer for Warren and then asking Victoria to increase her offer to match that. I think that could be considered to be a second breach. So you've got the first breach of accepting a higher offer than what was advertised, and then a second breach for asking Victoria to increase her offer. Obviously, properties, once the Renters' Rights Act comes in, properties must be let at the advertised price and there's no competitive bidding. So for me, this is probably a 2 breach situation. I also note from the summary that they demanded 6 months rent in advance. What's your thoughts on that, Josh?
Yeah, I think it's something that's often seen nowadays to try and overcome maybe credit referencing issues, or it's obviously going to be a preference of the landlord to take that sum. However, the Renters' Rights Act is pretty clear that rent in advance above 1 month's rent is prohibited. That again is going to be a breach of the Renters' Rights Act.
Yeah, absolutely. And it doesn't matter that Warren's offered to pay that amount. It can't be accepted. It's not just whether you're demanding it or requesting it, it's also accepting it as well. So I think there's probably a third breach lurking there too. And then finally, the comments on the children, however true or not they may be. This, I think, is again another breach. What's your thoughts?
It's one of those where it doesn't. It's a clumsy statement to make. It doesn't sound as though that's the main driver in this particular instance for why they might have chosen Warren over Victoria. But it does suggest a landlord who has a preference for tenants who don't have children, and that would potentially suggest discriminatory practices, which again, it's very clear under the Renters' Rights Act that's just not going to be permitted. I think you'd be looking at best practice if you're Hinden Homes of going back, looking at training, looking at your record keeping, and just making sure staff are trained so that if they're dealing with a situation, they just avoid those kind of clumsy statements, which could, when viewed in a certain way, be discrimination under the Renters' Rights Act.
Exactly. I mean, we're not obviously privy to any written documents in this case study, but you'd like to think none of these comments are committed to writing. I think one of the definite things that agents are going to have to do is look at their onboarding questionnaires and make sure that, any questions relating to whether or not you have children, whether or not you're, in receipt of benefits, things like that are worded really carefully so that, they're not seen as this is going to be a deciding factor as to whether you receive or whether you're successful in obtaining a tenancy or not. So shall we move on to case study 2? Just to say, we have obviously highlighted all of the breaches on the slide. So you will be receiving these slides at the end of the webinar, so you can go back and have a look at our musings on the topic afterwards. So case study 2, Josh.
So we've got case study 2. The scenario here with December 2026. James Reed has been offered a 1-year fixed-term contract in Plymouth. To avoid commuting from his home in Manchester, James and his family decide to rent a property in Plymouth. Their children will need to register at a new school, so they're looking for a property they can stay in for the full 12 months. The Reeds find a 4-bedroom property and contact the agent, Hemsley Homes. The agent sends them a questionnaire which includes the question, how long do you intend to rent the property for? The Reeds state 12 months and are offered a property on a 12-month fixed-term contract. Before signing the tenancy agreement, James asks the agent for permission to keep their family dog, a well-behaved miniature poodle, at the property. The agent agrees on the condition that the tenants pay a deposit of £200 and take out pet damage insurance. The tenancy begins. A few weeks later, Mrs. Reed's elderly mother in Manchester becomes seriously ill, and so she decides to return home with the children. When James contacts the agent to discuss ending the tenancy early, the agent insists that they are committed to the full 12-month term.
Uh-oh, sounds like bad news to me.
There's a few issues to unpick here. We've got the case study summary up there of the key facts to remember, and the discussion questions we're going to be looking at are: what provisions of the Renters' Rights Act have been breached and by whom? What grounds might it be reasonable to refuse a request for a pet? And what processes should Hemsley Homes update to ensure future compliance with the Renters' Rights Act? So in kicking off this one, Emma, what kind of immediately jumps out at you from this scenario?
Well, I think the first thing is that there's a fixed term in there, which, like we said at the beginning, that's going to be prohibited at the point that the Renters' Rights Act comes in, and any existing fixed term is going to automatically convert to a periodic tenancy. Any new tenancy that's granted after implementation of the Act is going to be known as an assured periodic tenancy. I've been using the acronym APTA to remind myself of that, which I think is a song in the charts at the moment. But anyway, moving on. And then, so yeah, I think that's the first really obvious breach in this case study, is the trying to purporting to grant a fixed term. Like we said, it's not just a case where if you granted a fixed term, that would be a breach, but also purporting to grant. So I think, any questions that are submitted to tenants that ask things like, how long are you planning on staying in the property, or trying to make inquiries to how long any previous tenancies they've had have been for, could actually amount to purporting to grant a fixed term. It doesn't matter whether the tenant wants a fixed term, which, based on our experience in the sector, tenants often do want fixed terms. So, that's something they're going to be affected potentially negatively by the Renters' Rights Act. But it doesn't matter whether the tenant wants one or not, you can't grant one. So I think for me, that's the most standout breach. And then obviously there's some interesting blurb about pets in that case study as well. So Josh, I don't know, have you seen the definition of pet in the Renters' Rights Act?
We were talking about this in advance of the session, and the definition of pet is it's an unusual one, and we were trying to sit there and think of something that wouldn't be a pet.
Exactly.
If you just remind us what the definition is, Emma.
So it's defined as an animal kept by a person, mainly for personal interest, companionship, or most weirdly, I think, ornamental purposes. So that is very broad. I don't know if you and any of the people that are on the webinar today sat through the the hustings for this, where they discussed pets and prohibition of pets for days on end. And, you know, obviously everyone's got a different opinion of pets and whether pets are good or not. But so Section 1, subsection 1 of the Animal Welfare Act describes an animal as a vertebrate other than man. So that would mean vertebrates include mammals, birds, fish, reptiles, and amphibians. So I think, sadly, for those landlords with phobias of spiders, snakes, lizards, that is going to come under the definition of pet based on the Act. Like Josh said, we sat and thought about what typical pets wouldn't come under the definition. We were struggling to find any. However, based on the definition of animal under the Animal Welfare Act, we came to the conclusion of slugs and stick insects. Now, I'm not sure how many people actually want to keep them for pets anyway, but I'm sure there are people out there that do. But this case study, obviously, the landlord's done the correct thing by allowing permission for the small dog, but there's another breach in there, isn't there, that's not so obvious?
Exactly. There is a breach by imposing a condition on the tenant that they pay an additional deposit and take out pet insurance. That's prohibited under the Renters' Rights Act, and it's a prohibited fee under the Tenant Fees Act as well. I think realistically, it's going to become very difficult for landlords to refuse pets. The types of situations where they will refuse are going to be quite limited. And it's really going to be balancing that reasonableness, but with a lens that it's going to have to seem reasonable unless the landlord can really show something that's deeply unreasonable. Type of scenario you might see maybe is a block of flats where the head lease prohibits a pet, or in certain situations where there's just an obvious safety need, which would mean that the type of pet that's being proposed is just not going to be reasonable, but it will be quite limited.
Yeah, I mean, in Devon, we might find there's more circumstances related to where there's like livestock close by to properties and stuff, which, you know, clearly not going to want big, angry, aggressive dogs next to that. That might be something that's reasonable, but some of this is going to be not determined until we have some, you know, case law on it. In terms of policies and procedures, I mean, I think Hemsley Homes need to make sure that if they are asking tenants to provide details of pets that they're seeking permission for, that perhaps they create a questionnaire that has, you know, basic questions about, you know, how long has the tenant owned the pet, what pet is it, obviously, what do they do for the things like the disposal of feces and stuff. I mean, it's all things that ordinarily you probably wouldn't think about, but if you've owned a pet yourself, you know, there can be additional obligations. But in terms of being able to object to a request, like we said, it's going to be relatively limited. So, there are going to be penalties imposed for those that refuse pets unnecessarily or unreasonably. So finally, we're going to move on to case study 3. So case study 3 relates to student tenancies and Section 8 notices. So the scenario, we have 6 first-year students at Exeter University who decide to secure accommodation ahead of their second year and find a 6-bedroom house through Talon Lets, a student letting company. They pay a security deposit and enter into a monthly assured periodic tenancy agreement in November 2026, which commences on the 1st of July 2027. After a positive year renting the property, students decide to stay on for their 3rd year. They start to notice that the property is falling into disrepair and the agents are not as responsive as they were previously. They then receive a Section 13 notice to increase the rent from £4,000 to £4,500 per calendar month, which is over and above the market rent for a similar property. After seeking advice from student housing, they apply to the first tier tribunal to have the rent determined. Several weeks later, and just before Christmas, they receive a Section 8 notice, happy Christmas students, under Ground 1A of the Housing Act. The notice expires at the end of April, just before their final exams. Upset, but feeling like they have no choice, the students move out before the notice expires and into an Airbnb for the last couple of months of their 3rd year. And then after their exams, one of the students, to their shock, sees the same property advertised through a different estate agent as a family home at an increased rent. So, discussion points for this case study, Josh. Is the tenancy agreement Renters' Rights Act compliant? What options are available to the tenants with regards to the disrepair? was the first tier tribunal application a trigger for the Section 8 notice, and what's the implication of that? And is there an issue with the landlords relying on ground 1A? What are the requirements, and can we see any breaches?
Thanks, Emma. I mean, there's certainly some issues to overcome on this. First point, just to recap, really, is ground 1A relates to a landlord intending to sell a property. I briefly covered off what was involved in that, which was a 4-month notice period and a prohibition on reletting for a period after that notice is served. In terms of the property falling into disrepair, that's an issue which spans multiple pieces of legislation, one of which is the Renters' Rights Act, and in particular, when the further phases of the Renters' Rights Act kick into place related to AWAB's law and the decent home standards, that would be expected to bite a little bit closer on this particular property. But certainly you can see that there's an issue for the landlord in terms of the condition of the property. The other point to note really is around the rent increase. As I mentioned earlier, rent increase is now going to be subject to the statutory procedure. That statutory procedure has been followed here, Section 13 notice served, but a rent increase above market rent. And clearly that's an issue. Tenants in this scenario are savvy enough to make a representation to the first tier property tribunal. That's just not going to be accepted. And there's likely to be a challenge which falls against the landlord in this situation, where the tenant's successful in showing that rent increase is just not acceptable. In terms of the tenancy being kind of valid and compliant, what are your thoughts on that one, Emma?
So I think the main issue here is that the landlord's choosing to rely on ground 1A, but the student has entered into the tenancy agreement in November 2026, but the tenancy doesn't commence until the 1st of July 2027. Now, there is actually a provision in ground A which specifies that you can't use the ground if the tenancy agreement was entered into more than 6 months before its commencement. I think that's obviously to try and discourage landlords from getting students signed up so far in advance and having a situation where you might have overlapping tenants and not a period to kind of remedy any issues. So, I mean, this one in particular, I think the landlord stumbled there by not complying with that. So regardless of, their intentions in relation to wanting to sell the property or not, they can't actually use the ground anyway. In terms of the disrepair, like you said, it doesn't really matter whether the Decent Home Standard or AWAB's law is in force yet or will be in force at the point of this case summary, because there's ample legislation out there already which they'd be able to bring a claim for disrepair against the landlord. We've got the Environmental Protection Act, we've got the Housing Act. There's so many breaches that could be brought to the court's attention based on already existing legislation. But in terms of, the Decent Home Standard and AWAB's law, that's just going to bring it to the forefront of the court's attention even more. And I mean, like you said, the first tier tribunal situation, given that they're now going to be removing the requirement that any increase would not be backdated, we're going to be in a situation where, tenants are actively encouraged to apply to the first tier tribunal for determination of the correct rent, because they've got nothing to lose. Because if it's going to be a situation where if the rent is determined that it is going to apply as the higher rent, they won't have to pay it until the date of the first tier tribunal determination. So if the first tier tribunal is inundated with people requesting a determination, that determination could take 6-12 months to achieve, in which case the tenant's got away with paying a reduced rent for 6 to 12 months. And that's, of course, assuming that the rent was determined to be correct and in line with market rates anyway. So there's several issues with this one, and the student accommodation ground is definitely going to be something that I think there's going to be several challenges to it, and there's going to be some issues that are going to have to come out in the wash, I think. Like I said, all of our discussion points and key takeaways are on the slide. So obviously the key takeaways from this one is that rent increases have to be reasonable and in line with market rates. Repairs must be carried out promptly and to meet legal standards. Possession grounds must be used honestly and transparently, and student and vulnerable tenants should be treated fairly to avoid reputational harm.
Exactly, and that applies, in terms of the misrepresentation of those grounds, that applies equally whether the tenant stays and challenges or whether they are served with a notice, like in this scenario, and leave voluntarily in that notice period.
Yeah, exactly. When you look at the sanctions, it doesn't just apply if they have tried to use that ground and then they've instigated proceedings. If the tenant can prove that they surrendered their tenancy because the tenant used a ground incorrectly and they felt maybe some kind of pressure to just leave because they thought, oh, well, they've served a notice, so I may as well just leave. That's enough to also get a financial penalty as well. So, it's not just a case of whether the landlord's actually acted on that ground, but also whether the tenant has acted differently or, tried to surrender their tenancy or surrendered their tenancy within 4 months of the date that notice was served. Then they're going to be able to prove that actually, that this is a circumstance where there has been a breach. So final considerations and takeaways before we go on to questions. So obviously, once the Renters' Rights Act comes in, there's going to be no accelerated possession route. So every possession claim is going to need a hearing to determine its merits and see if the landlord can meet the grounds that they are served their notice on. So obviously that's going to cause us some issues, isn't it, Josh?
It's going to cause a lot of issues. I mean, anyone who's familiar with the court process at the moment will realise it's not particularly speedy. Introducing more cases into the court process is going to make the whole process a lot more difficult. It's going to mean that landlords who might not be receiving any rent, might have difficulties with reletting properties, are going to have that longer period in order to get possession back, which is going to be a problem. How much of a problem, we're not entirely sure. There was envisaged to be a bit of research done as to the impact this would have on the courts. As far as we understand, that actually didn't take place. So how the court's going to balance all this, we're just not quite sure. The other thing that you really see throughout this, really, and like Emma said in the last scenario, tenants are going to have the opportunity to raise issues and do things that they probably wouldn't have done so before. And so, as a result of that, are we going to see an increase in financially incentivized surrenders? Are tenants going to be difficult knowing the rules are on their side? The ombudsman, potentially there's a process that's more difficult for landlords. So, what do you think, Emma? Are people going to be saying, well, I'll take cash to leave rather than having to have the landlord go through the court process?
I think there's definitely going to be an increase in financially incentivized surrenders. Landlords are going to be in situations where they don't have a ground that they can rely on, and they no longer have Section 21 to be able to rely on. So in those cases, their only option to be able to regain possession is going to be throw some money at the tenant and hope they're persuaded to leave. I just can't see that. The government have said they've taken into account every single circumstance with these new grounds, but the reality is they won't have. And some of the need for additional grounds isn't going to become apparent until Section 21 isn't in existence, because obviously, I think from what I understand, they were supposed to be consulting agents and lawyers who are typically serving Section 21 notices to find out the reasons behind why they were served previously. Again, not sure that ever happened. And also, it's not a question that we typically ask. If someone asks me to serve a Section 21 notice, provided that they meet the criteria to do so and the prerequisite requirements, we don't ask them why they want to terminate the tenancy, because we don't have to. So there's going to be reasons out there that aren't actually applied in a ground at the moment that's not going to come out until, these circumstances have been seen in front of the courts. So something else to consider, obviously the local authority have got to impose these civil penalties. Do we think they're going to be able to actually police this? I mean, do they have the funds, the budget, the resources to be able to go out there and actually enforce these obligations?
I mean, it's one of those situations where, with the local authority collecting money, from local landlords and keeping it, you can see them being incentivized to police this a little bit more strictly. Whether that happens in practice or not, it's really quite difficult to see. I mean, the introduction of the database and the Ombudsman service is going to make it more visible where rogue landlords are out there. So in theory, they could be kind of low-hanging fruit for a local authority, but whether that happens in practice, I'm just not sure that will be the priority of the local authority unless they can use it as a income generation. We've got to time now, so I think we'll have a look and see if there's any questions that we can answer briefly. And like I mentioned, we're very happy to engage with people offline, and this webinar will be circulated as well.
Yeah, exactly that. So I think there has been a question box, hasn't there, available? Let's have a quick look, see what questions we've got thus far.
So we've got a question here, which is, what is the latest date you can serve a Section 21 notice? This is a key topic, Emma, because a lot of landlords are thinking, well, if the current law is in place till April, can I take advantage of that? And how might that affect me if I'm kind of serving a notice now, but potentially spans into that new 1st of May phase 1 regime?
Exactly that. So we're in a situation where at the moment you can still serve your Section 21 notice, and you're going to be able to do that until the last working day of April. I would advise, though, that you don't wait until April to do that, because, especially not the end of April, because for a start, you've got to make sure that you've got all your documents in place, compliance, etc. Things like that take time to prepare. And also you don't really want to be, cutting it that close if you don't have to. And then we've got another question that in relation to the information sheet and whether this needs to be sent to all tenants. So is that going to also is that also going to be in place for those that don't come under the Renters' Rights Act? So, we've got some examples of contractual tenancies, Rent Act protected tenancies, and in terms of the information sheet, we don't actually know a huge amount at the moment, because the reality is that we haven't seen the information sheet that the government have prepared, so we don't know what information is contained in it. I think based on what I've read thus far and the commentary that's available, we're going to be in a situation where this information sheet is used to tell tenants about the Renters' Rights Act and its implications. So it seems to me that it's only going to be relevant for those tenancies that are actually caught by the Renters' Rights Act. But it remains to be seen, and it's probably something that we can follow up on once we are in a position that we've seen the actual information sheet that the government have prepared. So like Josh said, we are at time. So if anyone's got any other questions, feel free to follow up with an email to us, and we'd be more than happy to assist. For everyone that's made it to the end of the day and chose to listen to us as opposed to the budget announcement, thank you for your dedication. It's really appreciated. Our team are very active on LinkedIn, so please do connect with us if you'd like. We've got lots of articles and topics that are also included on our Renters' Rights Spotlight Hub, which is linked on this final slide here, where you can find many articles, insights relating to the Renters' Rights Act. And so if you or your clients have any queries, please direct them to this page, or alternatively contact one of our team. So thanks again for joining us today on our webinar on the Renters' Rights Act. We will probably see you again in the future, no doubt, when more guidance is released, or perhaps by 2035 or 2037 for the next instalment, when the Decent Home Standard comes in. But to be honest, I'm kind of hoping I might have won the lottery and can retire by then. But if not, we hope we see you again soon at our other events. And thanks again for joining us.
Thanks.